At the outset, may I thank the organizers of the lecture for inviting me to speak this morning. It has been always a great pleasure to address the students. When I was requested to come over to Dehradun, I immediately agreed, although it has been a long journey from Delhi, particularly the traffic which we face, whether in Delhi or Roorkee or in Doon itself. The topic chosen for today is very intellectually stimulating. If you read it in a narrow manner, it covers only the changing facets of the Constitution as we see or witnessing these days. But if you look at it from a little broader angle, it covers the changing facets which India has witnessed from in the last 2 centuries, and I would prefer to go by the latter because I have some interest and a flair for historic constitutional developments in India. Of course, history can be very alluring for some it may be boring, and if I bore somebody, I'm sorry for that. Friends, the constitutionalism. As we all understand, Constitution is a framework of norms wiring the political structure. There is always a political structure which can function without a constitution. But the modern world demands every political structure, a political power, should have a constitution which acts as a binding rule. Every framework of norms is not a constitution in the modern sense. Idi Amin, a great dictator, also had a constitution, but that's not the constitution in the modern sense. So what makes in the modern sense a constitution? That's very important. The modern constitution is necessitated when social contract theory of state advanced by David Hume and John Locke gained acceptance. It propounded that the birth of state is not founded in the divine right, but in the consent of those whom the state governed. As long as people thought that the king has his right to rule because of the divine grant, there was no constitutionalism in the right sense because it was not chosen by the people. But social contract theory, which gained its acceptance in the 18th century, raised the birth of a state to the acceptance of people. So acceptance of the people became a basis for the state. That's how the constitution comes into picture. If the state is a social contract between the people and those who govern, then it is necessary to have a written document or a convention by which the government is conducted. So that is how the constitutional idea came into the picture in the world. Then a sophistication in the constitution occurred as the time passed through, because every framework cannot be called a constitution. Then a thought occurred, started gaining acceptance that there should be rule of law. So the constitutional structure and the rule of law together produced a principle called constitutionalism, and perhaps in the 18th century it started gaining importance around the world. The Constitution is not a document which is expected to survive for a few decades. It is expected to survive for a long time. Therefore, the Constitution, as we all understand, should have an inbuilt mechanism for change, which can be done both by the legislature in India, which was Parliament, and by the judiciary, because judiciary has been recognized to have a power to rule on the constitutional validity of the acts of the state. This started with the ruling by US Supreme Court in Madison case. Till then, there was no such recognition that one arm of the state has a power to rule on the constitutionality or to bring a discipline in the constitution. How the constitution emerged in India is an interesting topic. India was not a single political entity before the British arrived. We were broadly known as Bharat in ancient times and later Hindustan. But this was not a nomenclature or a description in political sense. It was mainly a reference to the geography. The all land which sometimes we call India subcontinent was referred to as Bharat, and later the Europeans called it Hindustan. But the Europeans, when they started invading India, finally after a competition among them, the British power became dominant. After the Battle of Plassey in 1773, Third Anglo-Mysore War in 1799, Anglo-Maratha War in 1918, and defeat of Sikhs in 1839, and finally suppression of the rebellion in 1957, that we call the first freedom movement in India. The British power consolidated, and that gave rise to birth of India as a political entity. It took definite shape in 1858 when the British Parliament finally took over the territory from the East India Company and decided to administer India directly through the office of Secretary of State for India in London and Governor General of India sitting in Calcutta. It may look paradoxical if I say that constitutionalism in India came with the British imperialism, but it is true. The seeds started growing from there. So when do you fix it? I'm not going to fix it from the day the British Crown granted a charter to the East India Company to come and trade in India. Well, that's not the beginning of the Constitution. But definitely, 1773 is considered as the beginning of the constitutionalism in India. Why? It is the British Parliament on that day passed India Regulating Act, regulating the affairs of the East India Company with regard to its governance in India. Because by that time, after the Battle of Plassey, the East India Company had gained had been able to politically organize itself India. Then the British Parliament thought that it's no more safe for a trading company to rule India or over the people of India. The British Parliament passed the Regulating Act, and with this Regulating Act, the East India Company was made responsible to the British Parliament or to the people of Britain to answer its affairs. So with this comes a sense of responsibility to the governing company, that is East India Company, and it became answerable to, not to the Indians of course, it became answerable to some people somewhere, that is the British people in England, of course elected people in Britain. Then came certain issues. The East India Company introduced an independent judiciary in India, and the independent judiciary did not have a smooth sailing. The first Chief Justice of India in 1774, Lord Impey, asserted his power, as judges do assert nowadays also, by reference to Constitution. He said, my power to rule has come from the British Crown. I'm not going to answer to this company. The company is subordinate to me. So he asserted his power. And in this assertion of power by Lord Impey, he was supported by then Governor General of India, Warren Hastings. But The Governor General Council, consisting of 7-8 members, they are wholly opposed to this. So there was a big tension, a clash between the executive arm of the government and the judiciary. So much so, finally, both Warren Hastings and MP were subjected to impeachment proceedings in Great Britain, and that is a sad story of Nandakumar, because Nandakumar was ordered to be hanged, was convicted by the Chief Justice MP, and which was questioned in British Parliament as an act of misconduct by MP and led to the impeachment proceedings. Why I am saying all this is how the constitutionalism started growing in India, by asserting one being a power in relation to another being. But both were sincere that we have a power granted by the law. Who had is a different matter, but the struggle started in this fashion. Then comes 1858, finally the British Parliament decided to take over the territory of India and vest it in the British Crown, that the King or the Queen. Why it became necessary? Because by the time the liberal movement started in England, they thought that it is too much to allow a trading company to rule in India directly without being much responsible to the people in England. Although it was reporting to the Parliament from 1773 onwards, but still it was thought it's not safe to vest the power of governance in the hands of a company. Therefore, the British government, British Parliament decided to vest the power in the Crown to be ruled by the officers appointed by the Crown. That gave rise to the birth of Indian Civil Service, predecessor to the present Indian Administrative Service. The officers were appointed by the Secretary of State in London. ICS had an interesting beginning. It was not responsible to the Governor General in India. The contract was not with the Governor General. Contract was with the Secretary of State in London. So they too thought that they are not answerable to anyone in India, but only to the British government, that is Secretary of State, who was a member of the British Cabinet. That's how the government of India in 1858 started. Soon the British Parliament realized that sitting in London, it's not possible for it to make laws. Then they introduced India Council in 1877. Good. And India Council had a couple of Indian members also, but nominated, not elected members. And the process of legislation started. For the next 60 years, or to 61 years, we can call, till 1919, what we had was a strong bureaucratic government in India, of course with the Legislative Council, a small body to legislate. The foundations of rule of law were more firmly laid. The judiciary was absolutely independent in those days, so it continues to be now also, despite all the pressures and other things. So that gives rise to the birth of independent judiciary in India, independent judges with a high salary of 4,000 rupees in 1862, with a princely amount, and the gold was just 5 rupees per 10 grams. And that's how the process started. Then the demand started in India. The freedom movement was picked up. Indian National Congress was formed in 1885 to multiply the British immediately. It was basically to organize the Indian opinion and for Britishers to know what Indians want. But later, by the end of the century or the beginning of the 20th century, Tilak turned the organization into an organization for the freedom movement, that is Swaraj. Later Mahatma Gandhi came, and after what happened in Amritsar, it turned into a mass movement, and the British had to yield. And in 1890, constitutional reforms first came to India. What are those reforms? Nothing great again. What they did is, they divided the power between the center and the provinces. So provincialization started. And in the province, they created a diarchy system where some departments, some ministries were given to the Indians, and some important ones were retained by the British, where only British officials or nominated their executives can hold the post. This did not satisfy Indians. Naturally, it led to the further demands. Finally, in 1935, Government of India Act was passed, which really devolved most of the powers into the hands of elected government. But elected government was not elected by the people on a franchise. It was elected by a different system. But there was still a sense of some sort of a people's participation under the Government of India Act 1935. Then finally in 1947, British said goodbye, or we draw them out, whatever it is. I believe we draw them out by a freedom movement led by the Mahatma Gandhi through the non-violent means. And at that time, the British passed the law called Indian Independence Act. The students of constitutional history, students of constitution, should first read this act. This is the act which gave birth to India. Under this act, systematically, the sovereign power of the British Parliament to govern over the territory of India was transferred to the Constituent Assembly. The Constituent Assembly formed in India and Pakistan were vested with sovereign power to frame the constitution for the respective territory. Because the British, before they left India on 15th of August, on 14th of August, they partitioned India into Dominion of India and Dominion of Pakistan. So one side is India and another side is Pakistan, whatever. So these two organs were vested with the sovereign power to frame the constitution for the respective territory. But this is not all. What you see in India today, 1/3 of it was not a part of British India. It was under the princely states. There were 568 princely states roughly in those days. Some of the prominent princely states were like Mysore, the biggest was Hyderabad, Mysore, Kashmir, Baroda, Gwalior, Indore, there are plenty like that. So these princely states were independent states, but they were under the control of the British because British Crown had a paramount power or a suzerainty over these princes. There is a lot of debate what are the status of the princely states or the native states or Indian states they call them. They did not have an relationship with the British Crown governed by the international law because they were not on equal status with the British Crown. They are also not feudatories in that sense that British Crown could do what he likes. And there was no constitutional relationship because British Parliament didn't have really a power to pass a legislation against or in respect to the princely state. Even the cases decided by the courts in the princely states ended thereat. No appeal went to the Privy Council. The Privy Council declined to entertain any appeal on a ground that princely states are independent and separate and they are sovereign body. We do not entertain any appeal in the Privy Council. So that was the status of these states, Indian states, native states. When the British left in 1947, they terminated all their authority, or a paramountcy it was called then, with regard to the princely state and left them free. This created a problem whether these states can stay independent and assert their separate status. But they could not because as long as they were with the British, they were not allowed to develop their own army. They didn't have the strength to stand on their own legs. They had no choice but either join India or Pakistan depending upon the way which was convenient to them or which was contiguous. So most of the princely states joined India and agreed to frame the Constitution of India. Therefore, the source of power of the Constitution of India comes from two sources. One, the power transferred by the British Parliament under the Indian Independence Act. Secondly, the voluntary participation by the princes or the princely states in the framing of the Constitution and agreeing to adopt it as the Constitution of their state. This is how the source of power for the Constitution of India derives. Finally, in 1950, we framed the Constitution of India. There was some kind of a special privilege was given, status was given in respect of Kashmir. The reasons are different, which you have been reading, and I do not have to get into that in this my lecture. But apart from that, most of the 50 states merged into India fully and became a part of India. Sorry. A stage where India was able to frame its own constitution in 1950. So what this constitution is? This constitution framed in 1950 is modeled on the Government of India Act 1935. But the Government of India Act 1935 did not have power of a judicial review with the most important aspect of the constitution. It didn't vest any powers in the High Court or the Federal Court then concealed with the power to rule on the constitutionality of the acts passed by the Parliament or the whatever the legislature. Whereas our constitution, presently framed, though largely modeled on the Government of India Act 1935, introduced two important chapters. One is Part 3 of the Constitution, that is guaranteeing fundamental rights of the people. These guarantees, if you apply the social contract theory, are the rights retained by the people while constituting themselves a Constitution of India. Therefore, if you read the preamble of the Constitution of India, it doesn't say that this Constitution is framed because the power came from the voluntary accession by the princely states or from the British Parliament. It says we the people, means we the people have gathered and through their representatives framed this Constitution. Of course, in Article 395, it quietly says, Constitution, we hereby repeal the Indian Independence Act 1947. The link is kept in a legal sense, but in a political sense, the Constitution begins by saying, we the people of India, we have decided to constitute this sovereign nation. That's how both the doctrines have been married in this present Constitution you read. Since 1950, the Constitution of India has seen many facets. What are the facets? It's like a diamond. You go on cutting it, it gives a different facet. Sometimes it loses its value. The Kohinoor diamond had about 345 carats. Now it is less than 250 because it was cut to the shape to look more beautiful. So like that, the Constitution of India has also been cut, defined, chiseled by the Supreme Court and also by the Parliament, responding to the needs of the people or socio-economic forces that emerge. In the last 70 years, you students have studied better than I remember, or your lecturers and professors know it better. Indian Constitution has gone through several phases. I would broadly say that there were three important aspects to be considered. First is property. The property lost the battle in India. It's a history now. The students of this generation do not really much study about what happened from 1950 to 1983 till the Minerva Mills case. As a student, when we studied Constitution in 1982, 81 and all, this was the most important topic to be taught. We really spent a lot of time on that, but it is not necessary. In fact, most of the textbooks also do not really deal with that. What is this property? Juridically, you all know that the rights of man or woman are divided into three aspects. Right to property, right to body and right to mind. So property is one of the important aspects of human right. Accordingly, the framers of the Constitution had granted right to own property under Article 91F of the Constitution. Then again in Article 31, they restricted the powers of the state by making it clear nobody shall be deprived of his property except by procedure established by law. This compelled the state to pass a law before it acts upon somebody's property. The executive was deprived of direct powers by reference to its executive powers to take somebody's property. Then the question came, well, if Parliament passes the law and takes away my property, is that enough? Then the court said, no. In a civilized nation, if the property of somebody is to be taken in public interest, first you have to prove public interest, then you have to pay the compensation. But this payment of compensation was found to be a heavy burden for the government of India because in 1950, as India adopted the constitution, that was a time when the lands in India, 90% of the lands in India were held by the Jamindars or the landlords. Different revenue system existed in different parts of the country, but in sum and substance, the tillers of the land didn't have the ownership of the land. They only tilled at the mercy of a landlord or a Jamindar. Jamindar or landlords were more of an intermediary between the government and the tiller. So, one of the important promise which Mahatma Gandhi, Jawaharlal Nehru or the Communist Party made during the freedom movement is, as soon as India gains independence, it's not only a political independence from the colonial power, the land reforms will be pushed in and the tillers will be vested with full ownership rights to own the land. They are freed from the clutches of the Jamindars and landlords. Accordingly, the Jamindari Abolition Act came. In various states, various laws were passed to remove the Jamindars and pass on the ownership in the hands of the tillers. The landlords and Jamindars naturally objected to this and said, well, you can take away our property, but you'll have to give us the compensation. The state has, no doubt, a power to take over the property, power of eminent domain. Among 6 powers which a constitutional state has, which I broadly classify, one is power of regulation, that's called police power. You regulate various activities, and if somebody doesn't obey, you will be visited with a penalty. Second most important power, which is an attribute of sovereignty, is power of eminent domain, to acquire the property. But acquisition can't be it is not actually the expropriation of the property. It is an acquisition on payment of compensation. Then the third power is the power to tax. By taxing, you control the economy. In taxing, you will be able to generate funds for the government to take up its developmental activities, to maintain its army, to maintain its police, to maintain its judicial system, etc. Then the fourth is the government has the power to conduct its own business. Government can run any business. Government was running railway business. It still runs the railway business. Government can form a company or can do it directly. This is how the various powers of the government. Then the last is the power to print the currency. This is an exclusive power granted to the government. The government has the power to print the notes and act as a central banker. So this is how the powers of the government are broadly constitutionally classified. So when the power of the government to acquire property came up, the right to property of the people was projected against that. The resistance went on. The court ruled in favor of the people, beginning from the Kameshwar case in 1951 in Patna High Court. And immediately the constitutional amendments were carried on. So it went on the struggle between the both. Finally, the court upheld various constitutional amendments. Briefly, Article 31A, B and C. This article diluted completely the right to property of citizens. I'm not saying it was not justified. The concept was, at that time, a socialistic concept that a state should have a power to push the land reforms, agrarian reforms, and remove the concentration of wealth. That's all it was done. It was done. So finally, in 1978, the Parliament decided to delete even whatever little was left in Article 19(1), yeah, and that's how right to property was removed. Although under Article 300A, right to property is still retained as a constitutional right, but nothing really survives there. It is more of a symbolic right. So really the powers of the state under Article 31A, 31B, 31C are overriding. Therefore, one can safely say that property lost the battle in India. Next is basic structure. What is basic structure? You have been all very familiar with that. It's a matter of constitutional law. The single contribution of the Indian Supreme Court, Indian judiciary, is basic structure doctrine. Such a doctrine, such a constitutional, higher constitutional law over the written constitution is nowhere recognized. The first country where it was really recognized is India. Although there have been some kind of observations in the US Supreme Court and in one decision in Pakistan Supreme Court. But really, in an authoritative sense, by majority, it was first time ruled by the Indian Supreme Court. It made an implied limitation in the power of the Parliament to amend the Constitution under Article 368. It made it very clear the Parliament can amend any part of the Constitution. However, it shall not take away the basic structure of the Constitution. What's basic structure is a matter of debate, but broadly it includes independence of judiciary, rule of law, rule of equality, and federal structure, so on. There have been a lot of debate whether this basic structure is the reinvention of the old debate of supremacy of a natural law over the written law as John Austin understood it. But this debate still remains to be resolved. In the meanwhile, several other countries in the world have been able to adopt the doctrine of basic structure to restrain their parliament from behaving like a bully. It has happened in Bangladesh, it was in Sri Lanka, to some extent in Pakistan, Singapore, so many countries. But still in the Western countries, the basic structure doctrine has not been accepted. In England, in 2002, after the serial bombings in the train, a debate started when the British Parliament, when a bill was introduced to the British Parliament with regard to the immigration. The bill proposed a tribunal and made its decision final for all the purposes and made it very clear under no circumstances in any appeal will lie to any court or any court can exercise any writ jurisdiction. So it all became final. Then a lot of people asked the question, does it mean that the judiciary has no role with regard to the immigrants? Lord's Committee gave its report expressing its concern that it violates rule of law. But if the British Parliament is supreme, it can do man a woman and woman a man. Why can't it do this also? But an opinion gained in Britain that there is something called a higher law. They didn't call it a basic structure. They call it a rule of law, which acts as a restraint over the British Parliament. But British Parliament finally bowed down to the people. The bill was not passed. Government withdrew the bill. That's how an eventual tussle between the British Parliament and the rule of law, as we have faced in India, Article 368, was avoided. This is how the basic structure doctrine, evolved by the Indian Supreme Court, had its ripples around the world. Next comes, very interesting, which you all students of law been studying. Triple Talaq regenerated Royappa, doctrine of arbitrariness, and it put the legislative wisdom in question. What I mean to say is, as we all know, Article 14 guarantees right to equality. It is both positive and negative. The courts adopted the test of classification to test whether a particular law has violated Article 14 or not. But in 1976, Supreme Court found that test of classification is not really adequate to test whether a particular law violates Article 14 or not. The test of arbitrariness was introduced. Then the debate started whether this test of arbitrariness applies to the legislative actions or not. Will it only apply to the executive actions? For over last 40 years, excepting one or two cases, the court applied the test of arbitrariness only against the executive actions. Because it's such a strong test, anything can be knocked out by the court by saying it is arbitrary. So the court found it difficult to accept the test of arbitrariness as applicable against the legislative actions. But recently in Triple Talaq case, Justice Nariman and Dalit clarified that it does apply against legislative actions. So as a result, what happens? The Royappa is regenerated now, and we have reached a stage where we can drag the legislative wisdom for trial in the court. We can question the legislative wisdom on what basis you have made this law. Whether you have made this law or the measures we have adopted in a particular law are proportionate or excessive, or was it at all required to make this law? So all these kind of questions were earlier not asked. Earlier, the judicial review was confined to the questions whether the parliament, the legislature has the power or competence or not, then whether it infringes any of the fundamental rights. In a sense, does it violate classification test for testing Article 14, or does it violate any of the fundamental rights guaranteed under 19 and 21, the matter ended. Any of the vested rights guaranteed. This test of arbitrariness is actually takes us to the situation to question why the legislature has made this law. What business it has got to make this law? Was it a correct response? Is it an excessive response? So all these questions will come. As a result, series of law passed in the last 100 years, both through the British Parliament, Indian legislature, and the Parliament after independence, are exposed to the test of, are now have to be tested, are exposed to the test of unconstitutionality, because they can be challenged on the ground of Article 14. 377 was challenged, finally struck down, and of course the criminal defamation survived. Still the test was not introduced. If it is applied, I don't know what happens. It may not stand the test of arbitrariness. It may have to be declared as unconstitutional. So as many provisions of the IPC may fall for declaration as unconstitutional on application of the arbitrariness test. So this arbitrariness test is an important facet of the Constitution which our Supreme Court has enunciated. Then we go to the last one, very interesting, that Maneka liberated life and liberty. How did Maneka liberate life and liberty? Article 21, which is very dear to all of you, it says, nobody shall be deprived of his life or personal liberty except by a procedure established by law. Supreme Court in Gopalan case way back in 1950 said, well, this only requires a law to be made, that's all. At the most, this Article 21 is only a restraint against the legislature. Restraint against the executive. That executive cannot act on its own with regard to the life or personal liberty of a citizen. It has no powers unless there is a law made by the legislature. If the legislature makes a law and gives a power, the legislature can act. If the legislature makes a law and gives a power to the police officer that if somebody tries to act smart, shoot at him, then that's a valid law. So it was just read mechanically in Gopalan case that a law is enough. Once a law is made by this legislature or this parliament, that is enough guarantee of liberty and life of a citizen. But in 1978, Supreme Court said, no, that's not a sufficient guarantee. The law has to be, the procedure has to be tested on the principles of reasonableness. So that is a big departure in 1978, which Maneka Gandhi case made. It really liberated the liberty and life and made it more meaningful. But it's not here which stops really. People will all refer to Maneka Gandhi case and say things change, but real changes come later. When does it come? Article 21 guarantees liberty, that's the freedom. Professor of jurisprudence will tell you a right has four connotations, four variants. Right means a freedom. Freedom means I do what I like. That's all. Others should not interfere into my freedom. Second aspect of a right is claim. That claim means I want something which others are duty bound to give. Third aspect is a power. Power gives a discretion, and of course no duty is imposed on anyone. Then immunity. There are four variants of right. Article 21 as read conceived only a freedom, that is life and personal liberty, liberty to do what you like. If what you like is being stopped by the government, then that law is unconstitutional. That's all. But the Supreme Court went ahead. No. Article 21 is not just a negative right. It's not only a freedom. It's a positive right. So what is this positive right? The positive right is that Article 21 gives certain claims to the citizens against the state. So this concept of turning Article 21 from a liberty or a freedom into a claim made a great difference. Once it was recognized as a positive right in Muni Krishnan case in 1990, a claim against the state became responsible to fulfill all those rights. Take for example, right to health, right to education, or right to food. Right to food means right to freedom of food means I have got freedom to eat the food. Well, you eat. Then what is unconstitutional? If the state makes a law saying that don't eat in the morning, only eat in the evening, then it is unconstitutional. But if you do not eat, if you do not have the food to eat, the state is not responsible. If it is strictly read Article 21 as granting a freedom. But if it is read as a claim against the state, then state cannot sit and see somebody in the street dying without a food. It has an obligation to go and provide a food to eat. So the meaning of Article 21 was completely changed by the Supreme Court, first with Maneka Gandhi case, then really with Muni Krishnan case and subsequent cases. Now the Article 21 right is read as a claim and the responsibility of the state to fulfill that right, that claim. As a result, we have seen a series of cases are decided to the Supreme Court, directing the government to provide various services, health services. Roads are constructed, right to be constructed. Right to education is conceived. And it goes on, list goes on, there is endless. Because everything is necessary to fulfill the life of a person. All freedoms, all aspects of liberty which are now the claims are necessary. Then the question comes, can the court direct anyone? No. Court is also a little careful in this regard. It has two constraints. People can't come to the court and say, I don't have a house, give me a house. People can't come and say, I don't have food, give me the food. Then where will the money come? Where will the state give from? So the court in Harvard case very interestingly said, and correctly, that the purse lies with the government, executive government. It's they who tax, they who print the notes, and they who decide what should be the size of the budget, how it should be carried on in the economy, in the overall economy of the country. So we cannot burden the state beyond a reasonable limit. So we'll have to consider the financial capacity of the state before directing the state to undertake particular measure or provide services to the people. Secondly, the court also said, if extension of any service or discharge of a responsibility under Article 21 requires a legislation, then we cannot direct the legislature to make a law. It can be done at the executive level, it can be done, and nothing beyond that. Therefore, these are the two constraints. One is financial capacity of the state, another is inability of the court to direct the legislature, which are acted as a barrier for complete fulfillment of the right under Article 21. Article 21, today, as we have, makes India a welfare state. This kind of a responsibility was put only in the socialist countries or the communist countries, where the injunctions were issued under the constitution to the government, we shall do this, and so and so. Of course, there is no judiciary in the communist countries or socialist countries where the citizen can go and enforce. But the beauty of India is we have been able to translate Article 21 into an injunction or mandate against the state by making it a claim of the citizen. At the same time, we also granted a power to our judiciary to direct the government if the government does not act to provide for that. Subject to two limitations. One is the financial capacity, another is that it cannot direct the legislature. With these two constraints, Article 21 is being very meaningfully utilized in India to bring about concept of welfareism. Dear friends, I thank you very much for giving me an opportunity to speak. I'm sure you enjoyed it, although this is a topic which many may not like it. It will be boring also. Thank you very much.